In Illinois, as in all states, certain types of marriages are prohibited by law to uphold public policy and ethical considerations. Here are the types of marriages that are prohibited in Illinois. Number one, blood relatives. Marriage between close blood relatives is prohibited. This includes parent and child, siblings, and first cousins. However, first cousins may marry if they are both over the age of 50 or if one of them is unable to reproduce due to a medical condition. Number two, bigamy. Marrying someone who is already legally married to another person is illegal. A person must be legally divorced or have had their previous marriage annulled before they can marry again. Number three, underage marriage. Individuals under the age of 18 cannot marry without parental consent and or judicial approval. Additionally, individuals under the age of 16 are generally prohibited from marrying, with exceptions involving court approval under rare circumstances. Number four, lack of consent. Any marriage entered into without the free and full consent of both parties is prohibited. This includes situations where consent is obtained through force, duress, or fraud. Number five, same-sex marriage prohibitions. These were previously prohibited, but since the legalization of same-sex marriage in Illinois on June 1st, 2014, this is no longer a restriction. Number six, common law marriages. Illinois does not recognize common law marriages created within the state. However, Illinois will recognize a common law marriage that is legally established in another state where such marriages are legal. It's important for individuals to ensure that none of these prohibitions apply before attempting to marry in Illinois. Doing so under prohibited circumstances can result in the marriage being considered invalid and may have legal repercussions. If you are in a unique situation or have specific concerns, it is advisable to seek legal guidance to understand how the law applies to your circumstances. Call our office now.